I'll try and project it.
Alright guys, we're gonna get started. Can you hear me? Is this on? Is this working? Helping my voice at all? No? Okay. Alright, we will just yell. Or I can, if we have trouble with the sound, I'll get the person to put the microphone back up. Just a couple, first of all, welcome. We're so excited. This is our first Lunch and Learn post-COVID, we're glad to finally get back to some normalcy and see some faces in person. One note before we get started, our next training opportunity is coming up in September. It's a community mediation training, September 17th, 18th, and 19th. And it's free. We're just asking folks to sign up to volunteer for us. And as we recruit more volunteers, we'll have more training opportunities, but just give me a call. There's information on the table. Let me know if you're interested in that. We'd love to have you. This CLE was approved for credit. The number is, if you need it, is 218-498. If you forget that, email me. I can quickly shoot you the form that the CLE Commission gave me. There's also some out there. But I will send everyone who signed up, and if you haven't, please do sign up for credit if you need it as an attorney. I will send that to them. And now we'll get started. I'm so excited to introduce Adam Protheroe. He is from Appleseed Legal Justice Center in Columbia, where he directs their impact litigation efforts on behalf of low-income parties. Prior to that, he worked with the South Carolina Department of Consumer Affairs and South Carolina Legal Services. And we're so lucky to have him here to talk to us about South Carolina eviction law. So thank you, Adam, and I'll let you get started.
Thanks. Hopefully everybody can hear me okay. I'll try to keep up this volume. Is that okay for folks in the back of the room? We'll see how it goes. Okay. How many non-lawyers do we have here? Okay, great. I like these little mixed groups because you get interesting questions and perspectives. So as much as y'all have questions as we go through this, bring them up. I mean, I like Q&A, I like a conversation. It's more interesting for me, and that's the most important thing here, right? So let's talk a little bit about eviction law. Really, this is LandlordTenant law too. I want to start with, I guess, a little bit of context. Like, where are we right now? Because obviously, this is not a normal situation. And I get a lot of questions about, what are we going to see with these moratoriums and what's going to happen? It's really, really hard to predict, I think. This is the best prediction I can come up with, and I didn't really come up with it. I just sort of, this is the most kind of relevant thing, I think, is U.S. Census has been conducting some surveys throughout the pandemic, trying to figure out how many people are behind on rent, just how's stuff going for them. In South Carolina, that's our number. That's the number of people currently behind on rent. A lot of those people will have been protected by the CDC moratorium. They will be protected until Saturday. So what we're going to see on this coming Monday is a little hard to tell. My understanding is different courts have handled things a little differently. Some courts are accepting eviction filings and allowing the cases to go all the way up to the point that someone actually gets set out. They go through a hearing, they get to the point where, okay, we're going to issue the order, but we're going to stop right there. So it's possible that on Monday we see a flurry of thousands and thousands of eviction orders, thousands and thousands of new filings. So it's why groups like Mediation Center, groups like Legal Services, the work that they do is so important right now, because we're looking at a lot of people in need now and going to continue to be. Rent assistance has been another thing that's out there, and this is just kind of the two big rent assistance programs that are kind of making their way through the pipeline right now. One was created in December 2020 when Congress passed an appropriations bill. That's just a list of the allocations. Some counties got their own allocation, Greenville did, because it's large enough. And then for the counties that didn't get their own allocation, the state was given a chunk to run a program for the counties that didn't get their own allocation. So for the December 2020, about $346 million. My understanding is that less than $1 million of that has been handed out as of very recently. So, when we're looking at the hundreds of millions of dollars in back rent that's owed, the hundreds of thousands of families that are at risk, that needs to come out the door a lot faster. That's just my own editorial commentary. Then we have the second round of rental assistance, another $273 million and change that has yet to be appropriated by the state. I know some of the counties have started to tap into that money and use it, but that money's not even with an agency to be administered yet. But the crisis is now. So on that depressing note, let's talk a little bit about landlord-tenant law. I want to do a quick note about subsidized housing. I did a lot of work with subsidized housing when I was at Legal Services. Subsidized housing is complicated. I'm going to talk mostly about rules that kind of in general apply to private landlord-tenant situations. Subsidized housing always has different sets of rules, different sets of complications. The way to recognize subsidized housing is one of these three things is going to be happening. That if you're a lawyer, if your client is having to report their income on a regular basis to either a housing authority or to their landlord, they're having to income qualify for that housing. It's probably subsidized. It's probably one of those more complicated situations. If your client's rent changes when their income changes, it's definitely subsidized housing. And if your client has some kind of relationship with a housing authority, it's almost certainly some kind of subsidized housing. And there are a dozen flavors of subsidized housing, all with their different types of rules. And so typically I encourage people to call someone. I'm happy to talk with folks if you got a subsidized housing case. I know folks at Legal Services are too, because the consequences of losing a subsidized housing case can be greater even than the typical eviction. You don't just necessarily lose the right to live in a particular apartment. You can lose a rent subsidy. There may be affirmative claims that the person can bring. There may be other defenses. So I'm just putting that out there as if you think you got subsidized housing going on and you're not sure, please give somebody a call, because the consequences of losing can be pretty severe. So South Carolina landlord-tenant law, at least the statutory law, comes from a couple of different places. There is a set of old landlord-tenant statutes that have been around since, I don't remember exactly when they've been around since, but it's been a while. Longer than the SCRLTA, or the Residential Landlord-Tenant Act. That was passed in 1986 or 85, became effective in 86. And it covers rental agreements for a dwelling unit. And those two phrases are important there, rental agreement and dwelling unit. I'll talk about those a little bit more in a second. That law was a version of a uniform law that was passed in a lot of different states. Of course, we monkeyed around with it a little bit. We didn't just take the uniform law. In some ways, we monkeyed around with it in ways that made it more confusing, but that's what we have. One important thing about the Uniform Act, though, is that the rights and remedies there are not waived. A tenant can't sign an agreement that says, I waive my right to have a non-payment notice, for example, before you can file eviction against me for non-payment. They can't waive their right to have the landlord maintain the property. The rights that that act creates are not waivable. And if there's any other law in the books that's inconsistent, the Landlord-Tenant Act takes over. The lease is another source of law. I think I've had a law professor that called contract law private law. It's a law that parties create between themselves. And there are a lot of things that a lease can fill in the gaps about that the Landlord-Tenant Act doesn't cover. It's just a map of the states that have some version of the Uniform Landlord-Tenant Act. And so if you have a question about landlord-tenant law, South Carolina, if you can't find a case in South Carolina that answers your question, that's often true. We don't have a whole lot of appellate case law on landlord-tenant issues. Look into one of these other states might be helpful because they have laws that are at least somewhat similar to ours. So the presentation I've got here is longer than probably I can go through in any detail. So I'm going to be breezing through some of these slides. I'll share it with Jennifer. I know we can probably get this out to folks if folks are going to find it useful, because there's going to be more stuff in here than I can really read to you. I don't like reading to you anyway. So a rental agreement for a dwelling unit. Remember I said those two phrases are pretty important. The rental agreement doesn't have to be in writing. It includes all agreements, written or oral, valid rules and regulations that deal with occupying the dwelling unit, right? And the dwelling unit is pretty much anything that a person can or does live in, probably including a refrigerator box. It's a very, very broad definition, but there are some exclusions. These are times when the Residential Landlord-Tenant Act doesn't apply. If you're in an institution of some kind, and the fact that you're in that institution is incidental to detention, provision of medical, geriatric, educational, counseling, religious, or some other kind of service, I call this the prison exception. You don't have landlord-tenant rights in prison. Yes, it's probably a dwelling unit. Yes, there may be some kind of, I don't know if you call it an agreement to live there, but it could be considered a landlord-tenant situation, right? This takes it out of that. Contract of sale is another exception, and this is actually fairly common. You see a lot of rent-to-own agreements. Sometimes you call them bond for title, contract for deed, agreement for whatever. It's been called a lot of different things. If the agreement itself is truly a contract or sale, it does not fall under the Landlord-Tenant Act. Legal services we run into, and I'm sure you still run into lots of cases where you have a contract for sale. The landlord would like to file for eviction when the rent's behind rent. But it's a sale, it's not a lease. So you don't get to go to magistrate's court for an eviction in situations like that. Fraternal social organization, transient occupancy in a hotel or motel. I highlight transient because you do see a lot of long-term occupancy in buildings that call themselves motels. If it's more than 90 days, if it's something that's smaller than 6 units, it's clearly going to be under the Landlord-Tenant Act because it's not transient occupancy. It has to be transient. Possibly there are other situations that would be under the Landlord-Tenant Act too, but 90 days or less than 6 units would do it. And those are some other exceptions that come up a little less often. Let's talk a little bit about eviction defense. And in talking about eviction defense, we're really talking about the law of eviction. But one of the basics about eviction defense is that the court has to have jurisdiction, right? So there has to be a landlord-tenant relationship of some kind. And that's another reason why contracts for sale are not eviction-worthy cases. They shouldn't be held in eviction court because you don't have a landlord-tenant relationship. You have a buyer-seller relationship, and those two things are very different. So in order to have jurisdiction, there has to be a landlord-tenant relationship before the magistrate could do anything. So the landlord-tenant relationship is really broad. You don't have to have a written agreement. You don't really even have to have an express agreement. There's something called a tenant at will, which is a situation where somebody moves onto a piece of property, and maybe you didn't really have an express agreement for them to do it, but everybody's okay with it. That person may be a tenant at will, and that's still a tenant. So you don't have to have it written down. You don't even have to sit down and talk about it. You only have to agree to pay rent to be a tenant. So it's a really, really broad definition. There's a case down there, Bruce v. Durney, that kind of walks through the elements of what it is to have a landlord-tenant relationship. 1 second. See if this thing will work. So like I mentioned before, rent to own, bond for title, agreement for deed, that's not a landlord-tenant relationship. It's something else entirely, buy or sell. If there's a question of title to real property, that's another situation that I'd say isn't necessarily not a landlord-tenant relationship, but in some ways, those two things are mutually exclusive. One of the things that a landlord-tenant relationship has to be is there is a presumption that the tenant doesn't have any claim to the landlord's title. And if there's a question of title, well, maybe that's what you got. And so in some ways, those two things are mutually exclusive.
Sir, question, since it says that you're indicating there is no written agreement required, how do the courts feel about hearing a case when there is nothing in writing?
About as good as the lawyers feel when they have to deal with it too.
I mean, seriously,
Yeah,
I mean, will
sure.
they hear them?
Oh, sure. Yeah, well, they have to. And it's actually not that uncommon to have verbal leases. You know, I'll pay you $500 a month or something like that. Yeah, I mean, you don't have to have the written agreement. It's most common to do it. You know, I mean, oral contracts, with some exceptions, are, I mean, generally enforceable anyway. The problem is just proving what's the actual terms of the contract. So the courts.
Generally speaking, if you have a whole contract, the ones I'm associated with, primarily with real estate, they won't hear them.
Sure. Well, if you're talking about a contract for like sale of real estate, then those have to be in writing.
Okay.
There's a statute that says, statute of frauds, it says it has to be in writing. And there's a statute of frauds for leases too, but it's only leases that go longer than a year. So you can agree up to a year to have a verbal lease. If it's gonna go longer than a year, then to be enforceable, it has to be in writing.
So the courts will hear them.
They will, yeah, sure. Maybe this will work. Hey, well, never mind. Oh, well. So eviction is a two-step thing. The first step involves terminating the lease. Terminating the lease happens really exclusively between the parties. The next step is if the lease is validly terminated, and the tenant's still there, and the landlord still wants them out, the landlord can go to eviction court to try and make that happen. There are three grounds, and I'll go into a little bit more detail about that. There are three grounds for lease termination. In South Carolina, it's true in most states. Non-payment of rent, that's number one. Most common reason for eviction filing by far. Lease violations of some other type, you know, not just not paying rent, but let's say you tore up the property and didn't pay for it, disturbing your neighbors. It can be, there's a long list of things that could be. And finally, end of lease term. Just your lease is over and I want you out, but you didn't move. That's ground number three. So talking about step one, this is the way to, it essentially lays out the way to terminate a lease for each of those three reasons. For non-payment, you have to give 5 days written notice and opportunity to cure. I highlight those words for a reason. It has to be in writing. A lot of times it's not. And opportunity to cure. What we see sometimes is that we see a notice that says, you're behind in rent, you've got 5 days to move out. Wrong. You've got 5 days to pay your rent or we're gone. So there's a difference. There's always an opportunity to cure that's built in there. Now, here's the trick with non-payment though, is the notice can be included in the lease. So there's language, it's in the statute. It can be, if that language or something very close to it is included in the lease, the landlord doesn't have to give a separate notice once the tenant comes late. Once they get 5 days late, if they put that proper notice in the lease, they can go ahead and file an eviction court without giving them a separate piece of paper. The lease terminates at the end of that 5 day notice period, and 5 days is just the minimum. The landlord could give more than that. I've seen it happen sometimes, very, very few times, but occasionally you see something like that. So 5 days is the minimum. If the non-payment's not cured within that time, the lease terminates at the end of that notice period. Kind of works the same way for lease violations, except that typically it's 14 days notice, written again and again, opportunity to cure. There's some situations where that could legitimately be shortened to less than 14 days. Really kind of emergency situations. In practice, I don't think I've ever seen it done. It's odd to me sometimes that landlords don't try to do that more often, but typically what I'll see is either they give the good 14-day notice or they just screw up and give no notice at all, or they give a notice that says you violated your lease, you got to move out in 14 days, which is again, that doesn't give an opportunity to cure, so that's a problem. There's an argument that some kinds of criminal activity could be an exception to the requirement to give an opportunity to cure. Can argue it both ways. I'm not going to go too deep into that, but have to talk about it. Talk with anybody afterwards if you're interested. And like with non-payment, the lease terminates at the end of that notice period. End of the lease term is sort of similar, except that there's no opportunity to cure. If the lease is over, you give 30 days notice. Again, it has to be in writing, and the lease terminates at the end of that notice period. Yes?
I do work in mental health and substance abuse, and the question I commonly get from parents is how to get rid of their adult children. Either because they're possessing drugs or because they're just sitting there doing nothing. So would that fall under one of those, or is that outside of the scope?
Parents and kids things is a little tricky. Probably there is, I guess potentially there's some kind of landlord-tenant relationship there if it is an adult child. The argument around criminal activity, so it gets kind of messy.
Okay. So
the argument on criminal activity is, I see I've got 3 sections listed up there, 710, 720, and 540. They're all under that 27-40 title chapter. 540 talks about a tenant's obligation not to engage in criminal activity on the premises, and it doesn't specifically say anything about an opportunity to cure. So my thinking typically is, give an opportunity to cure is usually what I would tell landlords is just do it, and if they don't leave within that 14 days, then you can go on and go to eviction court. Rarely is there a reason why you have to try and move faster than that. But if there is, you can try it, and you can argue that criminal activity is an exception. You don't have to give opportunity to cure, but I don't know how much faster it's really going to move the case ultimately.
if the issue is just that they're sitting at home and not working and 35 years old.
Right. So there's an assumption that the law makes that a lease is month to month. So if there's no express agreement that says, hey, you can live here for a year, there's an assumption that it's month to month, and a tenancy like that could probably be terminated on 30 days notice without a reason being given. That's the last one.
Got it.
Yeah.
If you have provisions in the lease that go against, say, like a 5-day notice, 3-day notice, or let's just leave for not giving rent.
Yeah.
This statute supersedes the lease.
It does. Yeah, right. So that's a point I mentioned earlier, but it's good to reiterate that, is that, if the lease says, or if the lease says, I only have to give a 3-day notice, wrong. The statute says 5, and then you can't waive any of those rights in the lease. That's just right to notice. So here's step 2. That's kind of outline that I can think of. Landlord files, court issues what's called a rule to vacate or show cause, RTV, sometimes how I abbreviate it, some people do it that way. Tenant gets served with that rule to vacate. Once they're served, they have 10 days to do one of 2 things: move out or ask for a hearing. The law is a little bit unclear as to, the practice is a little clearer than the law, I'll put it that way. In practice, that's what their option is: request a hearing or move out. If no hearing is requested, the law requires the magistrate to issue a writ of ejectment. If it's not requested in 10 days, that's basically going to be the automatic outcome. Is an eviction order is issued. It's why I always tell people, don't ignore an eviction filing, even if you don't think you have a defense. Requesting a hearing, going to court, you might buy some extra time. You might buy, an issue that comes up in here is that all of these filings create public records, right? Landlords are more and more in the habit of, and third-party tenant screening companies are more and more in the habit of searching these public records and using them against people potentially in the future. If a case shows up that looks like an eviction order was issued, a landlord is more likely to look at that and say, you were evicted. If the case instead says settled, which is often going to be the outcome if you go to court and you say, hey, I'll move out, just give me an extra 5 days. The case disposition may be settled. That might be useful to the tenant in the future. Number 1, don't ignore it, because the automatic outcome is going to be an eviction order. And even if you're moving, number 2, you'd like for that case to show up settled instead of showing up writ of ejectment, which is what it's going to say if you don't do anything. So, wise, I guess. So no hearing requested, the writ goes out, the tenant gets served with the writ. After they're served with the writ, they have to give a minimum of 24 hours before they're set out by law enforcement. Most places that I run into give more than that. Not all places. I've seen some judges serve these writs from the bench. You have your 24 hours and their constable is going out the next day. A little harsh in my mind, but I come from the perspective I come from. But most places, it's a little more like 3 days, 5 days, something along those lines. But practice varies, and it's often up to the sheriff's department to how quickly they get around to these things. If a hearing is requested, you get a hearing. And the court finds one way or the other, finds for the landlord, finds for the tenant. A tenant can request a jury trial. As with any civil case, you've got a right to a jury trial. Usually this will trigger what's called what some people call a 790 hearing, a bond hearing. 790 refers to the section of the statute. And I think my next slide, no, not my next slide, but in a minute, I'll talk about bond hearings. In an eviction case, there's a limited remedy. You can't get damages in an eviction case. You can't get an order that says the tenant has to pay back rent. You can file a separate type of case to get that. But the only thing a judge can do in an eviction case is say evicted or not evicted. It's a limited remedy.
What about attorney's fees if they're built into the lease?
You can't get a judgment. So, I mean, you couldn't get any kind of order that says that those would be owed. You could file a separate action for that. But the court really only has jurisdiction to grant possession. One way or the other, right. Now, there's a little bit potentially an exception to that is that a tenant can bring counterclaims, and the court does have authority to hear those things and can potentially award damages to the counterclaims. But the landlord, if they want damages, would have to file a separate action, just a separate civil action. An eviction is basically, it's a special type of jurisdiction, it's a special cause of action, and that's essentially all that you can get there. So let's say no hearing is requested. I'm trying to lay out a little bit about what this timeline actually looks like in practice. And there's a little bit of wiggle room in these dates. Not all cases would lay out exactly this way, but this is kind of my best estimate after doing a few of these. So let's say on day one, landlord files, court issues the rule to vacate. That often happens on the same day. Tenant gets served the next day. The 10-day clock starts the day after service. So on day 13, that's the tenant's last day to request a hearing. On day 14, the court often has a little tickler system that tells them when these things are coming up. Tenant's not requested a hearing, the court will issue a writ of ejectment, which is the eviction order. It's possible for the tenant to be served the next day. As I mentioned before, I've seen them served the same day. Tenant has to be given a minimum of 24 hours. Day 16, the tenant could be evicted by law enforcement. That's a pretty quick timeline. There are a few places where it can move that quickly. More often than not, it's going to take a few more days than that. But that's kind of the tenant's in default, tenant doesn't do anything about it scenario. This next scenario is just an example of how, requesting a hearing and taking a few other steps can not just necessarily buy time, it may buy ways out of the eviction, but it can at the very least sometimes buy time. So day one, they file, day two, they're served. Let's say the tenant asks for a hearing on day 8. In the meantime, there are all these other options, right? Call legal services, apply for rent assistance, talk with the landlord, call on your family. There are a variety of things that somebody who actually engages in this case can do. But in the extra few days that hearing request buys you, that time can be golden. So let's say maybe day 15 or 20, decent guess, I think, based in practice. A hearing is usually scheduled within a week or two of the request. We'll see what happens when things start back up on Monday because there's going to be a huge backlog of cases. But tenant has another good opportunity to negotiate with the landlord there. I've settled a lot of cases standing outside the courtroom. Everybody's really motivated to not go into that courtroom sometimes, and that can be really helpful for both sides to maybe back off of whatever position they were standing on and work out something that's good for everybody. Judges sometimes will encourage settlements, even if there isn't a legal defense, they'll encourage giving a little extra time sometimes. So all those options are on the table, but they're less on the table if a tenant ignores the eviction filing. Yes?
In the event that you basically stated that you settled outside the courtroom, that still goes as it has been filed already, so it's still on that person's record.
Yeah, and it's if there are ways to avoid eviction filings in cases, I usually try to do that, because one problem that we run into is just the fact that the case is filed is sometimes used against the tenant. Whether the case says dismissed, whether it says writ of ejectment, whether it says settled, sometimes landlords look at that and say, I'm just not gonna mess with them. Sometimes tenant screening companies will pull these filings, and it's not real clear from that record what actually happened in the case. Actually, the way our court records work, can be really hard to tell what happened in the case anyway. If you look at the online court record only, you can never figure out from a court record whether someone was actually physically evicted by law enforcement. Because once the court issues the order, that's the end of the court record. It goes to the sheriff's department. It's an entirely different record keeping system, if record keeping even happens. So just the fact that a case says writ of ejectment doesn't mean a person was evicted. Oftentimes what happens is case gets filed, tenant talks to landlord, they work something out, they pay up, whatever. Neither party really does anything with the case, and it rolls forward until it says court issues a writ of ejectment. Law enforcement gets it. Maybe landlord calls law enforcement, maybe law enforcement shows up, landlord says, hey, no, we're cool, we worked it out. Well, that case still says writ of ejectment, even though that person may still be there. It's one of those issues with our online record systems that too much can be read into too little information. Yeah.
So in an instance like that, would it be something that the tenant could do to have it expunged if the eviction didn't actually take place?
I think I've tried that 8 times and gotten it done twice. It's doable. It's really unique situations where it's doable. I've never gotten it done where the landlord didn't agree and was willing to like sign on to the motion. Sometimes as part of a settlement, for example, let's say the tenant's got a good counterclaim. As part of the settlement, landlord will say, fine, I'll join in the motion to have this case removed, or basically have the tenant's name changed to just initials in the online system is what I've had done in the past, so that when somebody searches later on, it doesn't show up. But it's always been when landlord agrees, and even when landlord agrees, I've not always had courts that were willing to do it. It's a real problem that remedy isn't more available, I think, even in cases where the parties agree. But so it's doable, but it's like getting struck by lightning. I want to buzz through a little bit because I know we're.
Upstate Community Mediation is the provider of mediators for all eviction, or all magistrate cases that request a jury trial, which is a substantial number are evictions. So a lot of the folks in here, the ones that are going to be looking at this, are the mediators that go to magistrate court and hear all these cases. And they've started back up, I think, effective July. Mm-hmm. We're starting to back up. So, anything you can help the mediators, like understand the cases coming in, what are some ways that the mediators can help us resolve these things
Sure.
in that short little time that we have before the jury trial.
Yeah, I had some stuff, and I apologize, this presentation is based off something that was built for a longer talk. So, but yeah, let's talk about this just a little bit, because I do have a few things on that. Thinking about mediating these cases and how you would resolve them, thinking about what each party needs, right? Tenants often need rent. Right now, there's a lot of rental assistance out there. It's not coming out quickly enough, but those programs exist. And I think I've got a slide in a second talking about this, but if the landlord evicts, they probably lose access to the hundreds of billions or millions of dollars that are coming into the state, at least for that particular tenant, right? So tenant needs rent, landlord needs rent. That rental assistance may be a good way to push on folks to settle cases. Tenants need time, and more often than not, they need security deposit, moving money, that kind of thing. Even if they're able to move somewhere else, even if they have somewhere to go, even if they're willing, oftentimes, particularly talking about low-income tenants, security deposit, first month's rent, moving expenses is insurmountable. So, are there ways in settlement that you can make that happen? For example, can the landlord give the security deposit back early? If you really want this tenant out of here, that may be one way to make it happen, rather than waiting on your jury trial, which, how long are we talking for jury trials, do you think? 2 years? Before, really, what's the backlog going to look like? if you have a legitimate jury trial case, that's not just a non-payment case, because those are going to get dealt with probably in a 790 hearing. And when I said, so 790 hearing, I don't think I talked about that. You can't just ask for, like, if you have a case where rent is at issue, you can't just ask for a jury trial and just buy free time, essentially. What the court is probably going to do is set a bond hearing or a 790 hearing, because the tenant does have, under the statute, an obligation to pay whatever rent is due while the case goes forward. They've also got an obligation to pay any back rent that's owed. And if they don't do those things, then the eviction can go forward anyway, even if they've requested a jury trial. If they don't pay what's owed and what comes due while the case is going forward, they're out. Now, there can be some dispute about what's owed in terms of back rent or what the rent should be going forward. Let's say the landlord's not keeping the place up. You were paying $600, maybe it ain't worth $600. The judge can hear that and decide it, but they'll hear it early. They won't wait for the jury trial. So that's what's going to happen with 790 hearings. But yeah, I guess in terms of security deposits, moving money, a good reference, or at least a neutral reference from the landlord can be really helpful to tenants if they want to find somewhere else to live. I mean, if the landlord, tenant's trying to find somewhere else and the landlord's giving bad references, that really impedes them getting out, at least getting out of the place in a way that doesn't involve homelessness. Landlords need bucks. I understand that. I mean, I'm a tenant's advocate, but I know a lot of landlords are struggling right now, particularly. And so, you know, that's what they need. If that money can't come from the tenant, maybe it can come from rent assistance. They need some kind of assurance of future payment. How are they going to get possession of the property if they need that? And what's the condition of the property going to be? Those are things that they're going to be worried about, and things that you need to think through ways of how, you know, how can you deal with that? For example, maybe the tenant, oftentimes when cases have come to the point of eviction, everybody's at loggerheads. You know, I mean, this has been going on for a while. I think you're going to see a lot of the cases coming out of the pandemic. This stuff's been going on for months and months and months. And these things have been sitting in backlog, and everybody is going to be pissed, for lack of a better word. I mean, I think that you're going to see a lot more of that. And you know, mediators can do a whole lot to sort of short circuit that and try to take the personal out of it and talk to folks about really in terms of concrete needs. You know, what do you need out of this? You might need, I think I have a slide on this, hang on. This is what they think they need. But lawsuits never give you that. Like maybe sometimes in movies, but that's not really what you're gonna get. So I mean, even as a tenant's attorney representing tenants, I often approach folks, approach landlords kind of as a mediator. That's not my role, I'm an advocate. But approach it in terms of concretely, what do you need? And then approach my client the same way, concretely, what do you need? I know this has been going on for 2 years and you're really tired of it. And I know you hate this person to the core, but this isn't gonna, I mean, none of this is gonna solve any of that. So let's talk real concrete needs here. You know, maybe that's a helpful way to think about it in mediation. I think I had some other thoughts here too. So this is about the rental assistance. An eligible household is a renter household which has at least one or more individuals that qualifies for unemployment or has had some kind of financial hardship because of the pandemic, demonstrates a risk of experiencing homelessness or housing instability, and has a household income at or below 80% of area median income. That's a lot of people. But if you kick this tenant out, guess what? They're not eligible with respect to your unit anymore as a landlord. So that money's not coming out as fast as anybody wants, but it's not just aid to tenants, it's aid to landlords, it's both. And if you want access to it, we're gonna have to figure out a way for this person to still be there when it comes time for that money to come your way. I think that would be a powerful motivation. I hope it would be a powerful motivation. Another thought about, and I probably think about this too much from a perspective of a tenant's lawyer, but I can't help it because it's what I love. Collection in South Carolina this is not a great state to try and collect debts in. We don't have wage garnishment like a lot of states, or at least not for this type of debt. Quite a bit of property is exempt from collection under our bankruptcy exemptions, and our exemptions are pretty generous given the state's income level. I see Kathy nodding over there, knows bankruptcy very well. we have so many clients at and legal services serves lower income folks to begin with, but it was pretty rare when I was doing the little bit of bankruptcy I did to find somebody who you couldn't pretty much exempt everything. I mean, they had nothing, and especially if you took away, you know, I mean, if they're in a rent house, they don't have a home that you can collect against. You can probably find somewhere to squirrel away any property that a lower income family has. So really, there's nothing going to be, in a lot of cases, there's just nothing that's going to be collectible, practically speaking. And so, you know, unless you think they've got thousands of dollars squirreled away under their mattress, and you can get a hold of it before they squirrel it away under some other mattress, collecting that money is not going to be possible. The best way to get that money is rent assistance, if you're going to get it at all. So, more thoughts about. Let's see. Oh, cool. I had another thought too. Well, it's pretty much the same thought, but yeah, I mean, best assurance to get paid is if his Uncle Sam pays it, and if the tenant stays. So that's another sort of pressure point to bring parties together into something that works for everybody. This is something that this is a trap that a lot of people fall into, and a lot of tenants think. I've mentioned something like this before, that let's say my landlord files against me, I missed my rent payment, landlord files against me, I get caught up. If I was behind at the time they filed, basically if they had the right to evict me at the time they filed, it doesn't matter if I paid up. They can still insist on the eviction. Oftentimes they don't. Many cases settle with that scenario right there. They file for eviction and I pay up and we're all good. But it doesn't have to work that way. And something to be real careful about as an attorney or potentially as a mediator, whoever, is the idea that you have to make sure that you know what happens with that eviction case that got filed. Because again, if folks ignore it, it's going to roll forward, a writ of ejectment is going to come out, and that's an order that the landlord has a legal right to enforce. So if law enforcement shows up to enforce it, the landlord can say, sure, go ahead, and some do. So it's just something to be aware of. You have to know what happens with that case. So dismissal of the eviction case probably needs to be some part of the settlement, one way or the other. Or at least some kind of disposition of the case. And sometimes I've had landlords say, well, I want this case to stay pending to make sure that they get caught up or they don't get behind again for the next 6 months or whatever. It'd be hard pressed to find a judge that wants to keep an eviction case on their docket for 6 months just to wait and see what happens. So most likely it's going to be dismissal is like the practical remedy. But just make sure you know what happens in the
So
case.
with that, when we're dealing with our clients, on the thing that happens, we need to make sure that the landlord has reached out to the court system to make sure they've taken that off.
Right.
Well, they
To dismiss it. Yeah, dismiss it, settle it. And yeah, and oftentimes it's pretty informal. It could be a phone call, it could be an email, it might be a fax, who knows? But you want some kind of confirmation, ideally something in writing that shows the landlord has told the court, we're good, dismiss the case, settle the case, whatever. Dismiss versus settled, which is better for the tenant, who knows? I kind of like dismissed, but I don't know if it matters that much, practically speaking. But it's just something to be aware of in resolving these things. I had all sorts of thoughts about settlement. Look, I haven't been pretty small. Cool. Okay. So, I mean, what do you need to address in settlement? I'll put it in writing, you know, I don't think I need to tell any of y'all that, but, you know, if the tenant's moving, when, what happens if they don't move? If they're paying, when, how much, you know, spell those kinds of things out in the settlement agreement. What happens if they don't pay? What happens to the security deposit? Does the landlord get to inspect after the tenant moves out and deduct for damage? Most landlords will insist on that, and that's probably okay. Unless you really need to press for the security deposit to come back to the tenant so that they can get out. Those might be negotiated points too. If there's an eviction case pending, like I mentioned a minute ago, what happens to that? You need to know what happens to that because it's like a ticking time bomb. You're sitting over there. If you don't deal with it, it could be a real problem. Will the landlord give a good or maybe at least a neutral reference? I've got kind of a standard settlement thing that I used to use that, you know, it tweaked for each case, but it always included something like that, something like a neutral reference. You know, saying tenant was not evicted and moved out, the property's in good condition, and they didn't owe any money when they left. You know, those would be kind of that's probably a pretty positive reference, I think. And if you can get those terms, I think those are helpful. Are there any claims being waived? Let's say that the tenant have a counterclaim. Is that being dismissed? You probably have to address that. Is the settlement going to be a consent order? That could be more like a situation where a tenant's agreeing to move out by, August 31st. If they don't move out, the court can issue an eviction order at that point. Those are just things that probably you're going to need to address one way or the other. So we still got a little bit of time. Let me.
Hey, Adam, can you address also if the reason for the eviction notice is not for lack of payment of rent, but due to violation of other lease terms? Because I think there are many cases where there's a falling out in the relationship between the landlord and the tenant, and that's where it gets a little bit more difficult.
Yeah, I mean,
or lack of repairs. Let's say the
Sure.
landlord's not making repairs, so then the landlord in return tries to find some fine detail to.
right. It's a pretty broad topic. Is there a specific kind of situation?
How often is that happening now in terms
Always.
of eviction?
No, in terms, so with this caveat, I went to Appleseed for legal services about 3 years ago now, so I haven't done evictions during the pandemic. I haven't really been practicing in eviction court. I can throw it to any of my legal services friends or anybody else that's been practicing. How often is lease violation stuff coming up? I would imagine it's pretty similar to where it always was, which is like lion's share is non-payment, but the lease violation cases are certainly still out there.
Well, we see those primarily in the subsidized housing when the allegation is that there's a violation of the lease, and the client's position is that there's not, and that the provider, the owner, isn't doing what they're supposed to do under HUD regulations. And what we're seeing, obviously, Boulder Creek's all over the news. It's nothing new.
Mm-hmm.
The people that are, there's some units you'll never even see in court, but then there comes a Boulder Creek, which makes you realize that not every tenant can be wrong, that there's just a lack of training and lease violations are being filed against tenants to get them out without any merit behind them when they can be avoided. And those are probably all the cases that this group is going to see, because Boulder Creek has just bombarded the court system with file after file. And what they do instead is they try to terminate the lease on their own without a judge, and then they bring it into court as a non-payment of rent. And because they've raised it to fair market value. And for a mediator who doesn't have all the HUD education, it's going to be really tough to try to go against or even try to deal with.
Those are, and that's probably it's one of the reasons I mentioned subsidized housing early on, as this is really complicated. Please call somebody. Is that right there? So, but if we're talking about general lease violations, that stuff is still out there. I think the difference, and I can go into more detail in a second. The lease violations, arguably non-payment too, but lease violations, and this is kind of a general contract law principle. Like, if you to really breach a contract in a way that the other side has a right to sue you for eviction, for example, that breach has to be kind of serious. It's not, I dropped a gum wrapper outside my apartment and forgot to pick it up. It's something that needs to be pretty material. Sometimes you see cases that are brought over really minor, frivolous nonsense. Sometimes you see that in subsidized housing where it's really minor, frivolous nonsense or somebody not doing their job. But it has to be material, and there has to be an opportunity to cure. And then the question of whether it was cured in those cases is more complicated than did you pay your rent or did you not pay your rent? It's like, can you cure it? Did you cure it? So I know I'm kind of dancing around the question a little bit, but I'll touch on that on lease violations here a little bit in a second, and maybe go into a little bit more detail if other questions come up. But we had a few questions.
Well, it might not matter. I just, when you were referring to Boulder Creek Prevention, I didn't know what that reference was, but it might not matter.
Go ahead, Maureen.
Well, I was just going to say they're subsidized housing, and they've been just filing evictions after evictions, people that have been there 40 years, 50 years, 30 years, and their ledger system is impossible. We tape recorded, one, well, we got a tape from one hearing where they admit, oh, it would take us a week to explain our accounting system. And the judge evicted.
Like they
So
took
they
it.
couldn't even prove their case in court.
Yeah.
Now, we got that set aside, but that's how frustrated the courts are because it's complicated, and if they're not represented by an attorney, but basically it's.
Well, and they came under new management here recently, and I think that sounds like.
When Pat left,
Yeah.
I think they let her staff take over with minimal training, whereas a lot of the other housing units, you'll never even see them because their training is just so amazing. We had a person come in and tell us the way a case should have gone, and she worked for, I think she works for Shemwood. She could teach a course.
Yeah,
And
good.
she takes her job very seriously. She's very passionate. And
Very
yet
serious
it's-
job.
And she looked at these and she was just shocked that would go on for so long.
Sure. Yeah.
Which organizations are a red flag for me as a mediator that I need to make a phone call, besides Boulder Creek?
That's a question for the local folks. So, as far as like subsidized housing, like what would flag that for you? Or,
You covered that. I think.
yeah, you're just talking about like specifically which organizations are gonna be
Yeah,
really hard
because
to
she
deal with.
said there's some housing
Yeah.
organizations that go above and beyond, so I'm
Yeah.
not worried about them as a mediator, but I am concerned.
Well, Adam, you point to me, Adam's involved in a case right now against a housing organization or unit in Greenville that was, that's based on disparate impact. Because they were just
Yeah.
arbitrarily going through and removing people or trying to remove people from their housing.
It was a criminal records thing, and it's both of us. We're still, legal
Yeah.
services is working with us on this case too. So it was based on, they were doing criminal background checks, but they were using things like arrests instead, no conviction, just an arrest. Or they were using things, and these were all people that had been living there, some for years, things that had happened before they even moved in. They later said, oh, well, you have to move out because you have a criminal record. They hadn't been a bad tenant. They just did something, and often, and in really all of these cases, it's pretty minor stuff. So yeah, it's a fair housing case, which I'm happy to discuss later. I don't want to get into disparate
But
impact.
I'm just saying
Yeah.
so there's been a couple, but most are very, very good.
Yeah.
But those two
Yeah.
have been quite a challenge.
I would say talk with the legal services attorneys here. Who are the red flags? I didn't practice in Greenville primarily. I did some cases, but I was actually based out of Orangeburg office and did more stuff in there and like Low Country. So I know those areas a little better. But I'd say catch them afterwards. Maybe they can probably, without publicly defaming any organization. So I saw another hand here too. Maybe. Yeah.
I think the most cases I've seen lately is cases where the landlord, even though being that they're doing COVID-19 and moratorium, a lot of landlords have basically realized that they can't get their tenants out. So what they do is just basically go to the termination of the lease, because a lot of them now are
Doing end of lease term,
termination.
they're moving on month to month, or if they were on a year-long lease, we've been going for a little more than a year now,
So
so.
that's why I see a lot of them getting around the whole COVID situation, because
Yeah.
of course, that's not part of the COVID.
Yeah, it's, whether the moratorium covers those cases is arguable. Like, the moratorium itself doesn't say you can't evict for end of lease term. It says you can't evict for non-payment of rent. This came up a little bit earlier in the pandemic too, with landlords saying, okay, well, I can't evict for non-payment. I'm gonna give you 30-day notice then. And, should a court allow that when, you're really evicting for non-payment, right?
Right.
I mean, you're not doing it for this other reason. I always thought the best case, and I think we saw this a few times, where landlord filed a non-payment eviction case and he got put on hold because guess what? The CDC moratorium. Then they immediately filed an end of lease term case. Well, come on. Really. So, my argument would have been in those cases, yeah, this is a case that needs to be covered by the moratorium because we know the reason behind it. But the longer things went on, the more legitimate it is the claim that, hey, I had a year lease with this guy. I didn't intend to lease with him more than a year. And, it's not about non-payment, it's about end of lease term. But in any event, were there any other hands? Yes.
So with the number you gave earlier, 176,000 people behind in rent, and with the moratorium ending this week, and we've experienced because I work in university, we help assist with financial assistance and with, you know, SC housing, the slow process of getting things paid. And even for some of us who can pay a little bit quicker, landlords are refusing to accept rent. They're flat out stating they're out of here at the end of this month. So with all of this happening, is there anything for tenants? I mean, because they're at the end, so filing something like.
The point you bring up about landlords refusing rental assistance or rental assistance money, I think is a valid point. And if I'm representing a tenant in a case like this, I'm arguing that basically the tenant has offered you the rent. It might have come from United Way. It might have come from rental assistance programs. It might have come from a county level program. They've offered the rent and you refused it. And now you're filing a case saying my rent hasn't been paid. That's a self-inflicted injury. And you don't have a case. I mean, I would argue it that way. And I think there are situations where that may be a legitimate argument, where landlords are refusing to participate. And I've heard that a number of times, a verdict from groups across the state, that either landlords just don't respond, or they don't want to fill out the paperwork they need to fill out to get the money. They just want the tenant out. And it really shows, to me, an imbalance in the market when the landlords think, I'll just get somebody else. That really shows the balance of power we're talking about here. When they can refuse that money or willing to refuse that money just to get somebody out because they're ticked off with.
Well, especially with income based and with the way the rental real estate market is, and people are moving here in droves from metropolitan areas that pay, are used to paying more rent. This is an opportunity for them to get their right value.
Sure. Yeah, it's definitely a legitimate concern, and I think there are arguments there for tenants, but it's kind of case by case. So right here, Lindsay.
Adam, is that, so the only time the landlord is obligated to accept the money is during the right to cure period? After that, there's no obligation, no legal obligation for them to accept the money and keep the person in housing?
Strictly speaking, yes. Well, okay. Here's where I put my lawyer hat on just a little bit too. Strictly speaking, yes. I mean, I think the landlord's argument is that the statute gives them a 5-day cure period. They didn't cure within that 5 days. I've got a right to have them out. You can dig a little bit deeper into common law and basic principles of contract law to understand too that before, and there is some case law in the eviction code to help support this idea, that before a court can or should grant eviction, they need to consider some factors like, for example, what's the likelihood that the tenant is going to cure this breach? You can look to rental assistance for that. I mean, if the real issue is they owe $1,000 in back rent because they lost their job during the pandemic, and they've been approved for rental assistance, it's just not come down the pipe yet. I think the court can legitimately look at that and say, I'm not going to evict these people. There are principles of equity and there are principles of contract law that say, the chance that they're going to cure is, is out there, and I'm going to consider that. So I think courts can do it. I don't know how many are going to do it. One of the things that we did along with several other organizations, I think Legal Services signed on this letter too, was to ask court administration to issue some guidance to magistrates, just spelling out, what can you consider in these cases? And that is legitimately one of the things the court can consider is what's the chance that the tenant's going to cure it, whether it's within the 5 days or whether it's not. But I don't know, that guidance hasn't come out yet, but I think you can make that argument in case by case basis. We're like right up on time too. I'm happy to do Q&A or talk as long as y'all want to. So if there's anything else,
It seems like one thing that everybody in the room has ignored so far is the landlord situation. I'm a real estate attorney and I represent a lot of investors, and they don't have a margin.
Sure.
So, and they had a lot of people, as soon as that moratorium hit, people quit paying.
Yeah.
They hadn't lost their job. They're still working.
Yeah.
Or they get the super unemployment. So they were getting more than they were getting on their job, but they didn't have to pay their rent because you can't go out.
Yeah.
And so, one of mine had a tenant in commercial tenant, and the day it hit, they said, we're done.
Yeah.
That's $30,000 a month that he didn't have. So you're bankrupting the landlords because they don't, a lot of them, they've invested in rental property trying to build something or go into business for themselves.
Yeah.
They're not getting their rent and they can't pay their mortgages on the property.
Sure. And that's a legitimate perspective, right? And then, I come as a tenant's advocate, but I mean, looking at this at both sides, if there's not a supply of rental housing, there's not, the prices go up and tenants can't afford to live there, even more so than they can't afford to live there now. So it's definitely a legitimate perspective, especially for smaller landlords. A couple of concerns have been, like what happened after 2008 is consolidation. Smaller mom and pop landlords don't have the margin, can't make this work throughout the pandemic. They sell out, and your landlord is now a Wall Street bank, essentially, right? That relationship and the research on the relationship, how quickly those groups file eviction versus mom and pops, how much they work with tenants. And this is, I mean, it's not to say that they're necessarily bad. It's just on the aggregate, they tend to file eviction quicker. They tend to be a little less flexible. And is that a good thing on the whole for the tenants? I'm not sure either. So it's a legitimate perspective. One thing that sometimes gets missed in that conversation with mortgages, though, is that part of the CARES Act did put in place things like moratoriums on foreclosure and mortgage assistance. And so there's some assistance that's coming into that side as well. It's not just a pipeline that's through tenants. It's also a pipeline that's directly to landlords. But I mean, it's you definitely don't want to forget both sides of this, because people are hurting regardless of the rules here, definitely. So, thanks for bringing that up, because I know mostly, at least I see the people here, and my experience is not on the tenant side. But
but we know
If you're gonna do
landlords.
mediation,
Yeah.
Right.
if you're gonna do mediation, you better look at the other side.
No, exactly.
And find out if your person's behind because they legitimately lost their job and couldn't get unemployment, or did they get the extra 3 or 6 or whatever it was unemployment and just chose not to pay?
Sure.
Well, then as a landlord, I'm like, I thank you, you're gone.
Mhm.
You know, because you scammed the system, and that hurt me, and then I have the other side.
And I can see that perspective from a landlord, although, you know, maybe as a mediator, the question to that landlord is, are you concerned about getting rental assistance for that tenant for the back rent that you didn't get? Because if you really are concerned about that, maybe you need to put aside the feeling that they scammed the system and just understand that maybe that's the best way that you get your bottom line there too. So it's, I mean, I understand the consideration, and that's something about landlords being in their feelings. Tenants have all sorts of other reasons to be in their feelings too. And that's maybe one of the things to think about as a mediator is that's an obstacle that you may run into to settling kind of in everybody's best interest is people just ticked off because they think somebody else is doing wrong. My landlord's not keeping the property up, my tenant's been scamming the system. How much does that really matter to the things that a court can fix, that a mediation can fix? I can't fix any of that. That's already happened. That's behind us. What can we actually fix? But it's a mindset that is certainly going to be out there, and you know, some it has some stuff in reality. I mean, I'm not. I know some tenants are scamming this, and I get it. I have a tenants lawyer, but some people are doing it.
I think we should be super careful about saying scamming the system, because I think that is definitely like reinforcing a narrative that poor people are often trying to get something for nothing. So I would just encourage everybody to be very careful about using language like that. You know, when people invest in real estate, they're investing. That's a risk. And so that's something that we also have to consider too. Too often we put the burden on poor people. We want to say that they're attempting to scam the system or, you know, not pay their rent. And I think that the data overwhelmingly tells us that that's not the case. Most of the poor people are just struggling. and they can't
But I
pay
think
their
you're
rent.
dead wrong. If the day this moratorium goes in place, they haven't lost their job, they have no change in their financial, and they call their landlord and say, I'm not paying.
I'm just
rent."
explaining that the data
Yeah.
tells us that those folks are very
So
much
it
in
happens.
landlord.
Yeah,
Yeah,
it does happen. I think, at least from my understanding, and that there's been data that's put out with the industry. I think it was the National Multifamily Housing Council was tracking rent payment rates, right? And those rates didn't really decline that much for the most part over the pandemic. You saw a lot of people staying current. Now, granted, their data sample was probably not getting down into deep poverty. It was covering more middle income folks, but of that sample, I mean, rent payment rates stayed only a few percentage points lower than what they were pre-pandemic. So those cases probably do exist, no doubt. And I mean, I've worked in that community. I understand that some people will try to get whatever they can get out of it. But it's probably fewer and farther between sometimes.
But I'm just saying, if you're gonna do a mediation, you better find out if those feelings are out there.
Definitely. And
Because
absolutely,
you're not
I absolutely
gonna-
agree with that.
Until you address those.
Yeah, no, I absolutely agree with that. And to think about it
What relevant
critically,
is going to be, I mean, how can you really probe into these issues of whether somebody has, I mean, how can you really get into that in a mediation? What was whether they were legitimately not paying, or, I mean, I think that would be a difficult
Yeah.
lift. for a level, I think it'd be a difficult lift for a judge and a court, let alone a mediator, to be able to get back into people's motivations and what they were doing and not doing. That's a tough.
It would be,
thing to
definitely.
put on.
And time consuming, and, I mean, courts do it all the time. Courts do dig into those kinds of questions about what was somebody's motivation, what did they know, when did they know it, that kind of thing.
Without proof,
But
a lot of it's.
But it's a tough question, and it involves real judgment calls. And ultimately, I'm not a trained mediator. I did a lot of eviction cases and dealt with people who were in these situations quite a bit. And my approach over time just became try to steer people away from those ideas, because that's past. And it's not dollars, it's not cents, it's not concrete, it's not anything that anybody can do anything about right now. And maybe there's a better way than sort of reacting on feelings, and let's look at your bottom line and decide what's better on those terms. Yes.
I sit here hearing both sides of the story, both arguments, and I see people, as frequently happens, that are very passionate on both ends, which they need to be. As mediators, remember the word, we're neutral. That's not relevant. That really is not relevant for us as a mediator. And if we start making it relevant, we lost our efficiency and ability to be a mediator.
Sure.
And by the way, that's very easy to do. I mean, if you're not careful. But remember, that's not something we're involved in.
Sure.
We don't get involved in making judgment of whether somebody did the right thing or the wrong thing. We're here to try to help them solve a problem, so they go on with their lives, stay out of court if they question what we can.
I'd love to have you as a mediator. But I mean, the point's very well taken. I really appreciate you bringing it up, is that, something that can get lost is the perspective of both sides. And what are they really ticked off about? Oftentimes for tenants, it's how they were talked to is a big thing. Access, landlords coming in when they don't think they should be coming in, or feel like they're using that right to access to come into their home. The landlord's like, this is my property. The tenant says, this is my home. And there can be a lot of tension. More fights get started over access issues than, well, maybe not anything else, but it starts a lot of fights. And repairs. I mean, those are probably the big, unless y'all can think of any others, I mean, those are really the biggest tenant complaints. And so mindsets that you have to be prepared to think about as mediators is, those are things they're going to be ticked off about. If they're moving out, do the repairs matter? I mean, that's past in a way. Maybe it influences how settlement works, because that may be a counterclaim. But just in the same way that the landlord's mindset may be an obstacle to settlement too.
Do you have a list of resources for tenant or landlord rental assistance? Seems like that could turn.
The CFPB just launched that one thing. We're actually, but it wasn't as many as I thought, but that's one. We have
SC Housing listed, has a list, I think, too.
I looked through that list today, and almost every link leads to Greenville County DRAP
Yes.
and SC State.
They do.
Okay, yeah.
I have yet, and I have a couple of my colleagues going further, deeper, but no one said that they've seen any additional resources but those two.
I thought SC Housing had a list, did they not?
SC Housing,
Yeah,
the SC Stay.
right, but they have their county
agency.
programs.
The second program is SC Stay Plus.
Right,
That went to Greenville County, and that's being handled through the ERAP process.
yeah, but as far as other counties too, I thought SC Housing had a list of all the county level resources, and then Greenville County has their own program. SC Housing manages a program for, I think, 39 counties, and then there's a handful of others that have their own programs too. But I want to say, look at the SC Housing website. I think it's schousing.org, and I think they have a list of COVID-19 resources. That would be the first place I would look. So for rental assistance stuff. But I'm happy to talk afterwards. I don't want to keep anybody.
Yes.
Well,
Well, thank you. Thank you so much.
All right, well, we will see all of y'all next time, hopefully. I'll send out another one. We try to do these quarterly, so look for my emails.
Hey, good.
Thanks.
Yeah, I'll do like a little,
Yes, actually, I have that.